Qualifications and disqualifications to contest an election. Disclaimer: this training material is for use in training of election officials. It should not be referred as guidelines of ECI. In case of any variance in this training material, the ECI guidelines or rules or laws shall prevail. Learning outcomes. At the end of the session, the participants will be able to understand constitutional and statutory provisions on qualifications and disqualifications, understand the legal position that the qualification and disqualification of candidates is to be determined on the date fixed for scrutiny, know the importance of oath and affirmation, interpret various court's orders regarding qualifications and disqualifications, analyze the risks and ways to minimize them. Provisions in Constitution. Any person aspiring to be member of Lok Sabha or Legislative Assembly, whether by election or by nomination, must be qualified and must not be disqualified under the Constitution or under any law for such membership. For parliamentary election, qualifications are prescribed in Article 84 of Constitution. Disqualifications are prescribed in Article 102 of Constitution. For assembly elections, qualifications are prescribed in Article 173 of Constitution. Disqualifications are prescribed in Article 191 of Constitution. Crucial date for determining whether a candidate is qualified or disqualified is not the date of filing nomination paper but the date fixed for the scrutiny of nominations. Qualifications to contest an election. Qualifications to contest an election are constitutional qualifications mentioned in the Constitution, statutory qualifications framed by the Parliament. Constitutional qualifications. The constitutional qualifications as per the Constitution are citizenship of India, oath or affirmation to bear true faith and allegiance to the Constitution, minimum qualifying age. Citizenship of India. A non-citizen cannot be a contesting candidate in the elections. All about oath or affirmation. Purpose of oath. The real purpose of this oath or affirmation is that the person undertakes to bear true faith and allegiance to the Constitution and uphold the sovereignty and integrity of India. Oath to be made by. Every candidate has to make and subscribe either an oath in the name of God or a solemn affirmation in the form prescribed for the purpose in the third schedule to the Constitution. When to be made. Oath or affirmation must be made after the nomination paper has been submitted to RO. It must be made before the commencement of the date of scrutiny, that is, latest by midnight of the date preceding the date of scrutiny. Oath or affirmation by a candidate contesting election from more than one constituency, making and subscribing oath or affirmation in one constituency is sufficient if the candidate is contesting for the same house. Separate oath or affirmation is required if the candidate is contesting elections both to the Lok Sabha and to the Vidhan Sabha at a simultaneous election. Authorities before whom oath or affirmation to be made. RO or any of the assistant ROs of the constituency, all stipendiary magistrates of the first class, district judges and persons belonging to judicial service of the state. Superintendent of the prison if the candidate is confined in a prison. Commandant of the detention camp if the candidate is under preventive detention. Medical superintendent or medical practitioner attending to the candidate in case candidate is admitted in hospital. Diplomatic or consular representative of India in the country if the candidate is out of India. Any other person nominated by the ECI on application made to it. Certificate of oath to be given to the candidate without his applying for it. If taken before a different authority, onus is on candidate to produce certificate of oath before the RO. form of oath or affirmation in the Constitution of India. For parliamentary election, Form 3A in the 3rd schedule. For assembly election, Form 7A in the 3rd schedule. Age qualification. Minimum age 25 years. Age qualification should be fulfilled by the candidate on the date fixed for the scrutiny of nominations. Where the age of a candidate is not correctly shown in the electoral roll, he or she should mention his or her correct age in the nomination paper, as any such incorrect entry in the electoral roll will be overlooked by the RO. Statutory qualifications. In addition to constitutional qualifications, the Constitution has empowered Parliament to lay down such other qualifications for members of Lok Sabha or Vidhan Sabha as it considers and deems appropriate. As per Section 21E of RP Act 1951, elector to a constituency means a person whose name is entered in the electoral roll of the constituency for the time being in force and who is not subject to any disqualification as per Section 16 of RP Act 1950. Parliament can prescribe such additional qualifications under the Article 84C and 173C. These are contained in Chapters 1 and 2 of Part 2 of RP Act 1951. Lok Sabha registration as an elector. In the case of the constituencies, for Lok Sabha, registration as an elector. In the case of Lakshadweep ST, parliamentary constituencies, Sikkim parliamentary constituency and seats reserved for STs in autonomous districts of Assam, Lakshadweep, candidate should be a member of any ST of Lakshadweep and an elector in Lakshadweep. Sikkim parliamentary constituency, candidate should be an elector of parliamentary constituency of Sikkim. Autonomous district of Assam, candidate should be a member of ST of any autonomous district and elector for parliamentary constituency comprising such autonomous district. In the case of any other constituency in any state, the candidate should be an elector for any parliamentary constituency. For Vidhan Sabha, registration as an elector. The person has to be elector in the state from where he or she is contesting elections for Vidhan Sabha. Contest from SC seat. The person should belong to SC in the state from where he or she is contesting elections. Contest from ST seat. The person should belong to ST in the state from where he or she is contesting elections. Autonomous districts of Assam. In the case of a seat reserved for an autonomous district of Assam, the candidate should be a member of a scheduled tribe of any autonomous district and is an elector for the assembly constituency in which such seat or any other seat is reserved for that district. Registration as an elector in a state but SC/ST certificate from another state. A person is registered as elector in a particular state but he is a member of SC/ST of other state, then he or she cannot contest election from reserved seat. Lok Sabha or Vidhan Sabha, SC/ST person, election from general seat. A person is a member of SC/ST community, he or she can contest an election from a general constituency. Disqualifications to contest an election. Disqualifications to contest an election are of constitutional disqualifications mentioned in the Constitution, statutory disqualifications framed by the Parliament. Constitutional disqualifications. Basic disqualifications mentioned in the Constitution for membership of Parliament, Article 102, for membership of state legislatures, Article 191. Basic disqualifications mentioned in the Constitution are holding an office of profit under the government, being of unsoundness of mind, being an undischarged insolvent, non-citizenship of India or acknowledgement of allegiance or adherence to a foreign state, any other disqualification prescribed by the Parliament. Office of profit under the government. An office which is capable of yielding a profit or pecuniary gain, holding an office under the central or state government to which some pay, salary, emolument, remuneration, or non-compensatory allowance is attached. How to test? As per Supreme Court decisions in Shivamurthy Swamy Inamdar versus Agadi Sagananna Ananappa, following tests can be applied. Whether the government makes the appointment, whether the government has the right to remove or dismiss the holder, whether government pays remuneration. What is the functions of the holder are, and does he or she perform them for government? Does the government exercise any control over the performance of these functions? However, Parliament and all state legislatures have passed acts removing disqualification in respect of certain offices mentioned therein. Please refer to Central or State Act on removal of disqualification. When an office exempted from disqualification under the law, the holder of such office is not deemed to be holding office of profit, irrespective of receiving remuneration. Exceptions. Holding a post of minister in central government or state government doesn't mean office of profit. A person shall not be disqualified by reason only of the fact that he or she holds any of the offices of profit under government specified in the schedule. The list of various offices specified in the schedule is amended from time to time by the central or state governments. Generally, the posts of this type of various department or corporation or office remain in the list. Exception posts from the office of profit are Speaker or Deputy Speaker and Chairman or Deputy Chairman of the State Legislative Assembly, Minister or Parliamentary Secretary or Advocate General or Government Pleader or Public Prosecutor or Sarpanch. Official receiver appointed under the Insolvency and Bankruptcy Code 2016. Any office in the NCC or Territorial Army or Auxiliary Air Force or Defense Reserve, member of the Naval, Military or Air Forces or any other armed forces of the Union during the period the proclamation of emergency by the President of India dated 26 October 1962 and thereafter 6 months. Any office under an insurer, the management of whose controlled business is vested in the central government under the Life Insurance Act 1956. The office of the Leader of Opposition in Legislative Assembly. Chairman or Vice Chairman or President or Vice President or Managing Director or Director of a statutory body. Secretary of the Khadi and Village Industries Board. Chairman or Vice Chairman of corporations under the state government. Disqualification on the basis of unsound mind. A person is disqualified if he is of unsound mind, and such person should be so declared by a competent court under the Mental Health Care Act 2017. Disqualification in undischarged insolvency. A person is judged insolvent by a competent insolvency court under the Insolvency and Bankruptcy Code 2016. Mere commission of acts of insolvency not a ground for disqualification. Disqualification on this account ceases to be operative if the insolvency is discharged from insolvency by the competent court. Non-citizenship of India or acknowledgement of allegiance or adherence to a foreign state. Citizenship of India a fundamental and essential qualification. Additionally, a person shall be disqualified for being chosen as and also for being a member of parliament or state legislature if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance, or adherence to a foreign state. Statutory disqualifications. In addition to constitutional disqualifications, the Constitution has empowered Parliament to lay down such other disqualifications for membership of Lok Sabha or Vidhan Sabha as it considers and deems appropriate. The statutory disqualifications are mentioned in Chapter 3 of Part 2 of RP Act 1951. Statutory disqualifications are Section 8, Conviction for certain offences, Section 8A, Commission of corrupt practices, Section 9, Dismissal from government service for corruption or disloyalty, Section 9A, Contract with appropriate government, Section 10, Holding office under government company, Section 10A, Failure to lodge account of election expenses. Section 8.1, Conviction for offences mentioned in Section 8 of RP Act 1951 by trial court attracts disqualification. Release on bail does not remove disqualification unless conviction is also stayed during pendency of appeal. Please note the difference between release on bail versus stay on conviction. Disqualification commences from date of fine, that is conviction, and for a period of 6 years. Date of imprisonment and shall continue during the period of imprisonment till further period of 6 years since release from prison. Offences and period of imprisonment for disqualification. On conviction for offences mentioned under Section 8.1 of RP Act 1951, disqualification for 6 years even if there is no sentence of imprisonment. Offence of promotion of enmity between different groups on ground of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to maintenance of harmony. Bribery or undue influence of personation at an election. Offence of making statement creating or promoting enmity, hatred or ill will between classes or offence relating to such statement in any assembly engaged in the performance of religious worship or religious ceremonies. Offences relating to rape or offences of cruelty towards a woman. Offence of preaching and practice of untouchability. Offence of importing or exporting prohibited goods. Offence of being a member of an unlawful association. Offence under Foreign Exchange Regulation Act 1973. Offence under Narcotic Drugs and Psychotropic Substances Act 1985. Offence of committing terrorist acts. Offence under Prevention of Misuse of Religious Institutions Act 1988. Offence of conversion of a place of worship. Offence of promoting enmity between classes in connection with the election. Offence of removal of ballot papers from polling station, of booth capturing, of fraudulently defacing or destroying any nomination paper. Offence of insulting the Indian national flag or the Constitution of India. Offence of preventing singing of national anthem. Disqualifications under Section 8.2. Offences and period of imprisonment for disqualification. On conviction for offences mentioned under Section 8.2 of RP Act 1951, disqualification only if there is sentence or imprisonment for minimum 6 months. Hoarding or profiteering, adulteration of food or drugs, provisions under Dowry Act. Disqualification under Section 8.3. Offences and period of imprisonment for disqualification. On conviction for any other offences, minimum imprisonment of 2 years only will result in disqualification. Conviction for more than one offence in a common trial. In case of conviction for more than one offence in a common trial and with the sentences of imprisonment to run consecutively for the purposes of Section 8.3 RP Act 1951, the period of sentence of imprisonment for each offence should be added, and if the total length of time is 2 years or more, the convicted person shall be disqualified under Section 8.3 of RP Act 1951. Section 8A. Disqualification on ground of corrupt practices arises out of order passed by the President on the opinion tendered by ECI. List of such disqualified persons, if any, is circulated by ECI from time to time. To be noted, RO must check the updated list of disqualified persons and also note the time period for the disqualification as mentioned in the list. A person found guilty of corrupt practices in an election appeal may be disqualified for such period not exceeding 6 years. Section 9. A person who, having held an office under the Government of India or under the government of any state, has been dismissed for corruption or for disloyalty to the state shall be disqualified for a period of 5 years from the date of such dismissal. Dismissal from government service. A candidate dismissed from government service within the last 5 years must produce a certificate from ECI that he was not dismissed for corruption or disloyalty. Dismissal from government service. Filing of certificate. Such certificate must be filed with the nomination paper, otherwise nomination shall be rejected. Section 9A. A person is disqualified if the person subsists a contract in the course of his trade or business with the appropriate government. Appropriate government means central government in the case of election to parliament and state government in the case of election to state legislature. Contract should be subsisting on the date of scrutiny of nominations. Contract should be either for supply of goods to the government or for execution of works undertaken by the government. Contract with appropriate government. Where a contract has been fully performed by the person, contractor, and there was delay in the payment to him by the government, the contract shall be deemed not to subsist. Performance of services. Contract with appropriate government. A contract for the performance of any services undertaken by the government is no longer a disqualification. Meaning of contract. As per Article 299 of Constitution, contract means any such contract by the union or state government expressed to be made by the President or by the governor of the state, as the case may be, and shall be executed on behalf of the President or the governor by such persons and in such manner as he may direct or authorize. In Kannappa Rudrappa Nadgoda versus Vishwanath Reddy, the Supreme Court held that a contract for construction of roads and buildings was signed on behalf of the government by an executive engineer and not by the secretary to the government, and thus it did not comply with Article 299, but it was held operative against the contractor in so far as his disqualification under Section 9A of RP Act 1951 was concerned. In Mangilal versus Krishnaji Rao Pawar, the Supreme Court held that a company registered under the Indian Companies Act is a separate entity distinct from its shareholders. The chairman of the board of directors of the company, while functioning as such, cannot be said to be engaged in his trade or business as contemplated by Section 9A of RP Act 1951. In Shivamurthy Swami Inamdar versus Agadi Saganna Adanappa, Ranjit Singh versus Harmohinder Singh Pradhan, the Supreme Court held that a contract by the chairman of a cooperative society with the government was held not to be contract by the said chairman in the course of their trade or business, as it was entered into on behalf of the cooperative society, which was a separate legal entity. In Kannappa Rudrappa Nadgoda versus Vishwanath Reddy, the Supreme Court held that a contract by the government with a partnership firm will disqualify the partners of the firm. If there is a private dissolution of the partnership without any notice to the government, it will not absolve the partners of such dissolved firm of their liability under the contract with the government, and the partners will continue to be regarded as disqualified by reason of the contract with the government. Disqualification under Section 10. A person is disqualified for membership if and for so long as he is a managing agent, manager, or secretary of any corporation or company in the capital of which the appropriate government has not less than 25% share. Only secretary, manager, or managing agent of government company is disqualified. Government company means any company, corporation, etc. in which appropriate government has not less than 25% share and does not include cooperative society. Appropriate government means central government in the case of parliament and state government in the case of state legislature. Disqualification under section 10A. A person is disqualified for 3 years from date of order if he or she fails to lodge account of election expenses within the time 30 days from declaration of result by RO. In Shivaramagowda versus T.N. Chandrasekhar, Supreme Court held that the question of correctness or falsity of the account of election expenses can be decided by the Commission within the purview of Section 10A of RP Act 1951. In Shivaram Gowda vs. T.N. Chandrasekhar and Umlesh Yadav vs. ECI, the Supreme Court held that the question of correctness or falsity of the account of election expenses maintained by the candidate under Section 77 can be decided by the Commission within the purview of Section 10A of RP Act 1951. Please go through the list of disqualified persons in respect of your state carefully. ECI can reduce the period of disqualification in certain cases by a speaking order, copy of which will go to CEO. Accordingly, RO to coordinate with CEO. Risk matrix. Risk matrix for qualification and disqualification. The first risk is lack of pre-check. Its consequences will lead to delay at the time of scrutiny. Mitigation measures or action points for minimizing the risk are following a prescribed checklist, all nomination forms and accompanying documents like affidavit, electoral roll extract, caste certificate where needed, security deposit receipt, etc. must be checked after the nomination time closes. Second risk is apparent consultation at scrutiny time. Its consequences lead to avoidable complaints. Mitigation measures or action points for minimizing the risk are each and every case of doubt must be got clarified through legal division of the ECI much before the start of scrutiny. Under no circumstances should the RO be in telephonic consultation during the scrutiny. Third risk is not giving reasonable opportunity. Its consequences lead to avoidable election petitions. Mitigation measures or action points for minimizing the risk are even when the RO is very clear that there is no need to give time for resolving a particular objection or deficiency, it is prudent to give some reasonable opportunity if specifically requested by a candidate or agent. Fourth risk is wrongful rejection of a nomination. Its consequences can become a valid ground for setting aside the whole election. Mitigation measures or action points for minimizing the risk are after doing adequate scrutiny and analysis, in case of any doubt, the guiding principle should be to give the benefit of doubt to the candidate, as wrongful acceptance may not vitiate an election, but wrongful rejection can certainly become a ground for challenging the election. Fifth risk is perceived non-application of mind. Its consequences lead to election petition and also be a ground for doubting the validity of election. Mitigation measures or action points to minimize the risk are the RO may consult the legal division of the ECI or the office of the CEO or the observer present on the occasion, but he or she must apply his or her own mind on the facts and circumstances of the matter in question and arrive at a reasoned conclusion with a speaking order without any mention of such extraneous consultations. The RO has to be guided by his or her own judgment based on the position of law and applicable rulings without any apparent influence of outside opinion. In case of any doubt or any clarification, you can contact through the mail address shown on the screen. For other election related videos, you can visit the web address as shown. Thank you.